Good afternoon. Welcome to the TCLE webinar entitled 7 Things You Should Know About the New Missouri Commercial Receivership Act. My name is David Warfield, and I am the co-chair of Thompson Coburn's Financial Restructuring Practice Group. With me today are Cheryl Kelly and Brian Hockett, both of whom are partners in our Financial Restructuring Group. Cheryl and Brian also served on the committee that drafted this legislation. Receiverships have existed for centuries, dating back at least until 17th century England. Originally, they were a creature of equity, but receivership statutes were passed in many states during the 1800s, and at least in this country. That was probably because there was no federal bankruptcy statute during most of the 1800s. 3 different temporary bankruptcy statutes were passed that century, all in response to economic panics, but all of them were eventually and fairly quickly repealed. The Bankruptcy Act of 1898 was the first real permanent bankruptcy statute. The states stepped into this breach and passed their own receivership statutes to deal with insolvent enterprises. Railroad receiverships were quite common during the 19th century and even the first part of the 20th century. Missouri's experience was typical. It had receivership statutes dating back to the 1800s, but the current formulation of the statute, at least until this new bill becomes effective, was enacted in 1939. This statute is embodied in 3 short sections in Chapter 515. These sections, in the aggregate, total only 155 words. Rule 68.02 mirrors the statute and offers very little additional guidance. The use of receiverships throughout the country dwindled during the 20th century. The Bankruptcy Act and later the Code offered more certainty and greater protections. Missouri, like many states, developed little case law that fleshed out the meaning of those 155 words. The Lynch case up on the screen now is typical of the generalities you normally see in the reported cases of that era. About 15 years or so ago, however, receiverships became much more in vogue, particularly in single asset real estate cases. Many participants were growing tired of the burgeoning cost of Chapter 11 and instead began to file and pursue receiverships. All over the country, states began to re-examine their old statutes and considered new legislations to modernize them. So, Brian, when and how did the movement to modernize the Missouri receivership statute begin?
We started looking at the receivership statute at least 3, maybe even 4 years ago, when the Missouri Bar formed up a subcommittee. I mean, we started talking about it before the Missouri formed up a subcommittee, but then the Missouri Bar did form up a subcommittee to study the potential drafting of a more comprehensive and robust receivership statute. And this was done probably back in 2013.
And I think end of 2012, the group was formed populated with attorneys who are both on the debtor and creditor side of representation and various other parties that might be impacted by the receivership, such as utility regulators, utility providers, the insurance industry. Missouri bankers were certainly consulted, and various other parties and interests were consulted about the process.
And I know we spent a lot of time on it. I mean, there were over 50 meetings probably, and we spent hundreds, if not thousands of hours working on putting together the statute, or the draft bill, I guess I should call it. Now, in early May, the Missouri General Assembly finally passed the MCRA, and the bill has been forwarded to the governor for signature. It's not been signed yet, at least as of when I checked this morning. I'm not sure when it is scheduled to be signed, but given that it was universally supported in the General Assembly, I would expect that it will be signed, and it should go effective in late August. So what the MCRA provides, and we're going to go through, some of the provisions that the MCRA provides, just to provide people with additional information about where this statute is going from where it came. And the first step we're going to go through is the appointment of a receiver. And the MCRA still preserves the existing standards. In fact, it literally lifted the existing statute and placed it into Section 515.510. So it does preserve those existing standards, but it also adds specific instances in which the appointment of a receiver might be appropriate. And it is a permissive standard. It empowers the judge to appoint a receiver. It doesn't require the judge to appoint a receiver in any of these instances, but it does empower the judge. And it makes clear that certain instances are appropriate for the appointment of a receivership, including dissolution of a company, the enforcement of a lien on property, enforcement of a judgment. Also includes, specifically where the terms of a contract provide for the appointment of a receiver upon a default, then that's an appropriate instance in which a receiver could be appointed. The statute specifically provides for at least 7 days notice for a hearing on getting the appointment of a receiver. That time can be shortened for good cause, but typically you're going to be required to give notice unless you have a good reason not to. Under prior law, the appointment of a receiver was required to be ancillary to other relief. That is, typically you would file it as part of your relief that you were seeking in connection with like a breach of contract, usually a breach of a note or something like that, in order to enforce your security interest in property, and you would seek the relief ancillary to that. That was a requirement under the MCRA. The request for a receiver can actually be the primary relief sought in an action, although in most instances you're always going to be, seeking to enforce your rights in property, or otherwise seek to protect your rights with respect to property of the debtor.
And I would say this is ability to bring an original action for the appointment of a receiver as a cause of action is one of the unique aspects of the statute. That's a change from the original, body of receivership law in Missouri. It could be helpful if you have a non-recourse loan and can't find a claim to append your receivership to potentially. You can move to have the appointment of a receiver to protect the collateral and possibly to sell it, as we'll discuss, as an original receivership action.
And I think also it may also be important to have that in there when there is going to be a provision we'll discuss briefly later where receiverships in foreign jurisdictions will be recognized here. So if you needed to have a receivership recognized here, you could file it that way.
Well, under the Missouri Commercial Receivership Act, there's two types of receivers. A receiver is either a general receiver or a limited receiver. And the distinction of the type of receiver makes a difference as far as the scope of the duties and powers and obligations of the receiver. The court is, under the Act, supposed to identify whether the receivership is general or limited in nature. But if for some reason that doesn't happen, then the default is that the receivership is a general receivership. Basically, the differences between the two types of receiverships is that the general receiver takes control of substantially all of the debtor's assets and has broad duties and powers to operate the business. A limited receiver is going to take control over specific assets, and where the receivership is intended to cover only specific assets, the order appointing the receiver really should specify that.
In fact, it's a default position that it's a general receivership unless it's
correct.
A specific or a limited receiver.
And as a good practice, if you want a limited receivership, you should really say what the assets are that are under the control of the receiver. It's possible to convert one form of receivership to another on good cause shown with a motion to the court. And if a creditor has a lien on substantially all the debtor's assets, there's still an option under the Act to have a limited receivership, which might be helpful depending on the circumstances, because the general receiver has a lot more duties as far as noticing up the receivership and filing reports and doing certain other things. So you'll find throughout the Act that when you read about a general receiver, that receiver has more responsibilities, including a claims administration process, which we'll talk about later on.
So you were talking a little bit about duties and powers, and so with respect to duties of the receiver, there are certainly a lot more duties for a general receiver than there are for a limited receiver. And some of the duties that may apply to all receivers, I mean, in particular, sending notices within 10 days after the appointment, a receiver is required to send notices to all creditors. The debtor is required to cooperate with the receiver in providing information and to enable the receiver to send out those notices. Required to notify state and federal taxing authorities. A general receiver is required to send out, to publish notices in newspapers in the county or counties where property is known to be located. So that's obviously a significant additional duty that a general receiver has. Receivers should record notices in the land records, or is permitted and actually required to file notices in the land records where real property is at issue in the receivership. The receiver is required to prepare an initial report or schedules of assets and liabilities at the beginning of the case, actually within 30 days. The debtor is required to provide information to the receiver to help them do that. And then throughout the course of the receivership, a general receiver is required to provide reports, regular reports on assets and activities of the receivership. This enables the court and other parties to know what's going on with the receivership. A limited receivership may be required to also do reporting, but it's not specifically in the statute. It's just the court can, the authority of the court to require reporting from a limited receiver is in the statute. Now, with respect to powers of the receiver, prior to the MCRA going into effect, receivers are specifically empowered really in the orders of appointment. The orders of appointment that really are the central controlling factor in determining what a receiver's powers are. And this enabled some parties to probably overreach with respect to their authority over that a receiver might have. And sometimes it's also possible that an appointing order might be short of what a receiver might run into. And the purpose of the MCRA is to really be a gap filler for a lot of those situations. I think the intention was to empower a receiver to be able to do the things that are fairly typical that you would want a receiver to be empowered to, but also to enhance some of the authorities that he might have, as well as kind of fill in the gaps again to kind of make sure that a court knows what powers are and aren't appropriate. I do want to stress that the flexibility that was under the previous Act, I think still exists under this Act. I mean, the appointing court can really be very flexible in the appointing order in order to make sure that it fits a particular situation.
And I think it would be important to carry over practice from pre-Commercial Receivership Act to outline what powers you want your receiver to have, especially since there's now a formula for what are appropriate powers. You might as well import that into your order. So as Brian was saying, the statute, the MCRA does provide guidance to the court and to move-ins and other parties in interest as to what sorts of powers and authority a receiver would have once appointed. And essentially, those powers and authorizations are what you would expect for any party who's taking custody and control of assets to preserve and manage those assets and protect them, and then to operate the business in the ordinary course, and to marshal assets, pursue claims, pay expenses, hire professionals as appropriate, And all these things, if they're ordinary course, can generally take place outside the approval of the court. And the statute does contemplate all of that. In addition, the Act allows the receiver to recover assets. Specifically, there is a statute that covers the concept of turnover, which many of you may be familiar with as a bankruptcy concept as well. And essentially, a receiver or the debtor who is the subject of the receivership can demand turnover of property of the receivership estate that might be in the custody of control of someone else unless the court orders otherwise. The receiver is also given contempt powers to compel, or powers to compel turnover where a person over whom the court has jurisdiction has failed to respond to the demand. The receiver can pursue them and compel turnover. If there's a determination by the court that that demand was proper and the compelling is proper, then a party who fails to respond to the receiver and the demand to turn over property can be held in contempt. There's also a process by which the party upon whom the demand is made can postpone to preserve the status quo and protect the rights of both parties, maintain possession of the property, but post some security in lieu of the turnover. And that's a process that would require the court's involvement. The receiver can also sue and be sued in certain circumstances and can intervene in actions that the debtor may have been a proper party to. They may substitute in for actions of the debtor. They may also pursue fraudulent transfer actions under the Missouri Uniform Fraudulent Transfer Act, which I think the law was, certainly there was some support for that, but now it's been expressly stated in this Missouri Commercial Receivership Act. An additional power of the receiver that's worth noting is that the receiver can, when operating a business, obtain unsecured credit in the ordinary course of business, which makes sense. The receiver can also seek the extension of credit outside the ordinary course and pledge assets of the receivership when that makes sense to do with approval of the court.
So in thinking about some of the powers of a receiver, I think it's important to talk some about the jurisdictional limitations here that a Missouri state court could exercise. Certainly prior to the enactment of the MCRA, state court receivers are limited to the jurisdictional limits of a Missouri court, that is geographic borders. I have to say that's still true to a large degree. However, the Missouri Commercial Receivership Act now authorizes a Missouri-appointed receiver to go to another state that might recognize the receiver and seek recognition of the receivership in that other state. And on the flip side of that, the MCRA also provides for a mechanism by which Missouri courts are required to recognize the appointment of receivers from out of state. That is, an out-of-state receiver could come into the state of Missouri, and the Missouri courts are required to recognize that. That's why I suggested that a cause of action that might be filed is just a cause of action by an out-of-state receiver for the appointment of a receiver, for recognition of that receiver's duties. And the courts, as long as it's not going to lead to a manifest injustice, the Missouri courts are required to recognize that out-of-court receivership.
And I think these flexibilities and efforts to be extraterritorial can be helpful in certain cases, but it's always useful to keep in mind other remedies that the federal bankruptcy law and other multi-territorial laws might provide. It may not always be practical to be extraterritorial in a receivership, but certainly there's now a more flexible process to do that.
There's an opportunity for, the receiver has authority to go to another state. That doesn't mean the other state has to recognize it.
Right.
That's why, for you know, multi-jurisdictional type receivership. Certainly a federal court receivership is probably preferable. Obviously, that's only available where you can get subject matter jurisdiction in a federal court. Certainly, bankruptcy always provides for jurisdiction over property within, you know, within the state. So bankruptcy is probably the best remedy for that, but where it's not ideal, federal court receivership, and where you can't get federal court receivership, then this is available. So
I think one of the most important powers that is granted to the receiver under the Missouri Commercial Receivership Act is the power to sell assets. And under the Act, a receiver can use, sell, or lease property outside the ordinary course of business following notice and an opportunity to be heard. There has to be parties in interest who might be impacted by the sale need to be given notice and the opportunity to object. There are some limitations on what can be sold through a receivership. For example, farmland or personal residence. If the party owning the property does not consent to the sale, then you cannot sell the property over that party's objection. But essentially, in most instances where it seems appropriate to do a sale or some other lease or use of the property, the receiver can petition the court and seek opportunity to sell that property. And in most instances, that sale could be free and clear of liens if certain conditions are met. It's worth noting as well that the receiver law specifically authorizes a creditor, a lien holder, to credit bid its debt as part of the purchase price in a sale where the asset is subject to liens, and then when the property is sold, the liens will attach to the proceeds of sale in the order of the priority of the lien. So basically, the way the Act authorizes the sale is that the receiver will, again, move to sell the property, will need to explain the time and terms and conditions of the sale, provide an opportunity to object, and then any objections will be taken up at the hearing. A receiver can sell the property for less than the amount owed to the lien holders, the properly perfected holders of liens, if essentially the court can be convinced that the receiver sale is going to bring a fairer price or a better price than a sale outside of the receivership. And I think most of us can envision a circumstance where a receiver sale, where there's an opportunity to market property and to give parties the opportunity to see the assets and actually have competitive bidding, would be a better price than a non-judicial Missouri foreclosure sale, which takes place very quickly and with very few opportunities to really inspect the assets and bid for those assets. The other thing that the Act adopts is really a bankruptcy law concept, such that if a sale order that's been entered and approved by the court, it gets reversed, and the sale happens notwithstanding that reversal, absent a stay pending appeal or some evidence of bad faith on the part of the parties, that sale will be upheld notwithstanding the reversal of the sale order. One other thing that's worth noting is this ability to sell is a right that CMBS lenders or trustees of securitized lending arrangements like, because in a receivership, through a receiver sale, due to the laws that govern those kind of arrangements, they're able to finance the buyer of the property and keep that debt in place through a receiver sale. And one other thing I would just note is when dealing with tax credit types of transactions, you'll always want to keep in mind whether there's anything about the receivership that might trigger a recapture. And in most instances, that shouldn't happen if the proper documents are in place, but it's something to be sensitive to.
This was certainly one of the major changes that we looked at. I mean, this was one of the main reasons for looking at the receivership statute, was to make clear that a receiver appointed by a Missouri state court had the power to sell property. And one issue here is that getting insurance on a sale, an owner's policy on a sale from a receiver. And Cheryl, do you have any thoughts on that?
Well, that was one of the concerns in prior law, is that a receivership would get filed. There was no consent of the owner to the sale. That owner could trump the sale through the receivership, even if it might bring better value than outside of a receivership sale. And then you would turn to your title insurance company and say, will you insure the sale? We've got a court order, and there was concern about that. So now the Act does propose a process, and if you follow the process with proper notice to the creditors and get your title insurance company involved in reviewing the order, the notice process, and so on, it seems that there should be no issue with providing title insurance. I would say that you need to bring those folks to the table, the title insurers to the table early and often. Let them have the opportunity to see who you gave notice to. Let them look at the sale orders and get comfortable, but the Act certainly gives that opportunity for them to get comfortable.
So in my view, this is probably the most significant change that the new law makes. It clarifies the ability of a receiver to sell property of the receivership state, and arguably even expands that right beyond what a debtor in possession or a trustee would have under the bankruptcy code, because it seemingly permits a short sale over the opposition of an undersecured creditor. So this is, I think in practice, the bulk of receiverships are filed because there is a desire to sell some or all of the underlying assets. So this is tremendously significant, an improvement under the old law, immeasurably in my view. And I suspect we'll see develop over the course of time a practice in receiverships, not unlike bankruptcies, where bid procedures are considered and approved on an expedited basis, and sales are conducted pursuant to those procedures that are approved in advance.
Certainly the receiver sale gives some flexibility in those kind of procedures David described, where you can have competitive bidding and diligence packages are provided in advance and so forth, which is much different than foreclosure law, which now the receivership law says there's an alternative to foreclosure.
There's one other power that the receivership is authorized with under the MCRA is the power to assume, reject contracts. This is similar to 365 of the bankruptcy code, although, I mean, I have to say it is a lengthier section. It's certainly not as lengthy as 365 of the bankruptcy code. There are limitations to the ability to assume and reject that aren't otherwise, you might have available under the bankruptcy code. But the purpose here, I think, was to provide a receiver with a tool to use with respect to contracts. It does specifically authorize the receiver to do items such as assume and reject contracts. Now, in assuming a contract or rejecting the contract, that has to be approved on just and proper terms under the circumstances. So, I mean, the court could condition assumption on, obviously, cure that would be typical under 365, cure of defaults, and adequate assurance of future performance, or some other terms that might be necessary for a receivership court to approve that. Certain contracts can't be assumed. These are similar to the bankruptcy code. And these would be items that would, contracts with which the counterparty to the contract would not be required to perform to another person and would be excused under the law. Contracts for extension of credit, or simply that the contract is no longer executory and that the terms have expired. In addition, one important limitation here, I think, is that anti-assignment provisions in a contract are still enforceable. So if you're wanting to try to get value out of a contract by assigning it, you're going to have the consent and cooperation of the counterparty to that contract. That's one limitation under the MCRA provisions that would certainly leave the bankruptcy code provisions would be stronger, but that is one thing out there. I did want to note too that there is a automatic rejection of contracts with the state within 60 days after the filing of the receivership. So a receiver is, if there are state contracts that are important to the debtor's business, that's something that the receiver does have to pay attention to very quickly.
One feature of the Act is a temporary automatic stay that arrives on the appointment of the receiver. And this applies only in the general receivership type of case. It's limited in scope. At the beginning of the case, there's a 60-day stay against actions to continue or commence actions against the debtor or to obtain property of the receivership estate or execute on judgments against receivership property. One thing worth noting is that to get the advantage of this temporary automatic stay, if there's litigation in a court outside of the receivership court, then there needs to be a transcription in the other court relative to the receivership appointment. So there are some steps that might need to be taken to assure that this stay is enforced for your benefit as you may need it. The receivership stay does not stay all action. For example, set off. One can set off against property of the debtor that they're holding or monies that they're holding against a claim that they have, which is a bit different than the bankruptcy process. While bankruptcy recognizes set off and your right to set off, the stay is really, there's a status quo in bankruptcy that arises, and before setting off in bankruptcy, you really should get relief from the automatic stay. You can hold the money on a temporary freeze, but you can't set off. And the Receivership Act does not have that sort of a status quo. One can set off directly and immediately. Other sorts of actions that aren't stayed are what you might expect. Criminal proceedings, certain domestic relations types of proceedings, regulatory proceedings, certain types of perfection of liens type of situations, mechanic liens. And a party can move for relief from this temporary stay, and the court can grant that relief for cause. And also the court can enlarge or restrict the stay as may be appropriate. After the 60 days expires, there's still a permanent stay with respect to trying to collect against the debtor. You can liquidate your claim, but you can't collect, and to try to enforce liens against property of the estate. That type of a stay remains in place throughout the receivership.
Yeah, I think it's the protection of the receivership property that continues, and when the temporary stay is primarily designed to permit the receiver time to get control, get an understanding of the debtor's situation, and to get control over assets. Once the receivership has control over those assets are under the jurisdiction of the court, and the receivership assets are still going to be protected. I think after the 60-day stay is up, you could certainly proceed forward against the debtor as much as you wanted to, although especially in the instance of a general receiver, I'm not sure what good that's going to do you. I mean, if the receivership has the assets, substantially all of the assets of the debtor, your attempt to liquidate a claim and collect a claim against the debtor is going to be of fairly limited use when the property is in the receivership's possession.
That's right. It's a concept similar to bankruptcy court. Give us some breathing room, but also respect the rights of the other parties to liquidate their claims, certainly.
So one thing that was talked about a lot when we were discussing the MCRA was the impact on third parties and what kind of notices we wanted to provide third parties of a receivership, and you know, how do you bring them into the court if they want to come to the court. And one thing that, and I discussed some of these notice provisions earlier, but in the context of third parties, you know, rights here, then when I'm talking about third parties, obviously I'm talking about not a party to the action. So one creditor decides that a receiver is appropriate and files an action, and a receiver is appointed against the debtor. The third parties are obviously those that aren't parties to the action but might otherwise have an interest in the debtor. They might be a creditor of the debtor or some other interested party. A receiver is required to send notices to all parties in interest within 10 days. And again, that can be kind of a challenge to do, but the debtor is required to cooperate with the receiver. And there are requirements for what the notice is supposed to require. Also, a general receiver is required to publish notice in the county or counties where the receivership property is located. Again, this is designed to give parties, especially unknown parties, notice of the fact that a receiver has been appointed over the property. Any party in interest that wants to can certainly appear in a receivership action. They can ask for notices from the receivership court, and after they're asked for notices, they are entitled to get notices of most of the major actions that take place in the receivership proceedings. And creditors and parties in interest are entitled to participate, much like in a bankruptcy court. A third party can certainly weigh in on any action that the receivership's taking and any request that the receiver or other parties might make of the receivership court. I will note that the provisions of the Receivership Act do impose that you know, once a creditor receives notice or otherwise participates in the case or files a claim with the receiver, that the orders of that court with respect to the property of the receiver that are placed in the receivership are going to be binding on those parties. So obviously, if you are getting a notice of this, the third party might want to pay attention to a receivership action.
So as Brian was saying, third parties can be impacted and have certain rights and benefits and obligations in a receivership. The receiver is to give notice to all known creditors, and in a general receivership, there's a claims administration process very similar to bankruptcy court. Essentially, the general receiver will give notice to known creditors and parties that have made the receiver known, so made themselves known to the receiver. Those parties, in response to a notice to file claims, which typically would require 30 days response time, will need to file what's called a proof of claim under the Act. And that proof of claim needs to be so designated and include the amount that's due to that creditor as well as supporting documentation. And it will get served to the general receiver, as I said, usually 30 days after a notice of a claim bar date. The creditor is also to file a notice of claim with the receivership court, and that will not include all of the supporting documentation, but will evidence that they have, in fact, served and notified the receiver of their claim. So as noted before, the general receiver serves the function of marshaling assets, selling assets as appropriate, operating the business, and so on. And as that receiver collects the receivership proceeds, if you will, sales of assets and so forth, will then distribute those assets in accordance with a process and a distribution scheme that's laid out in the Missouri Commercial Receivership Act. And this priority scheme for distribution of proceeds of the receivership is very similar to what you would expect and what is seen in bankruptcy code, for example. The holders of validly perfected liens will have the proceeds of their collateral paid over to them in the order of the priority of their liens. And then after that, the proceeds will be distributed to the cost of the receivership estate. Those are administrative type claims. Then the third in priority is what's called a secured and unperfected class, and that's a bit different than what you would see in bankruptcy. Typically, the debtor in possession or the trustee would come in that place. They would trump any secured and unperfected creditor. But under the Commercial Receivership Act, a party who has a security interest that's unperfected could come ahead of others in the priority scheme and not be at the bottom of the heap as a general unsecured creditor. There are other layers, if you will, of distributions, wages, certain kinds of deposits, certain marital debts, governmental taxes, unsecured claims, with the residue, if any, to the debtor. And I should have noted earlier that as part of the receiver's administration of claims, the receiver is going to look at the different claims that are filed in the case and is going to determine whether to object to those claims, and those matters will be litigated in accordance with the process that's set forth in the Act. The proper filing of a proof of claim is prima facie or basic evidence that your claim is good. So the receiver will have the burden then after the claim is filed to object to that claim and show that it's not a valid and proper claim.
I wanted to note that with respect to the party that might be filing the claim, the provisions relating to distribution from a receivership do include, requirement that the person who filed the claim may very well be responsible for the expenses of the receivership estate. So, the priority scheme does list secured creditors first, and this suggests that the secured creditor would be the likely filer of the case, but any party that files a case may be required to pay the freight of the case. So that's certainly one issue that I wanted to highlight with respect to the priorities.
And I think that might have been the practice in the past, that the secured creditor as a movement for receivership would provide a carve-out or somehow enable the receiver to get paid. It's now part of the statute that whoever moves for the receiver is going to need to pay the freight somehow.
I think that most receivers aren't going to serve unless they know that there's a source to be paid. So, it is a practical issue as well, but in this case, there's provisions for the receivership expenses to be paid by a party who's, the property that's being administered, at least with respect to the expenses of it administering on those assets.
The Act does provide for a way to wind down the receivership and result in the discharge of the receiver. And basically, once the receiver's completed its gathering of the assets and objection of claims and distribution in accordance with the distribution scheme in the Act, then the receiver will apply for termination of the receivership. Before that order terminating the receiver and discharging the receiver and its bond from its status, then the court must first review a final report and accounting from the receiver. So a condition of the receiver's discharge is that final report and accounting be filed and be provided for parties and interest to review and potentially object to. Once the court reviews that final report and accounting, approves it, then the court is in a position to enter an order terminating the receivership and discharging the receiver. And once that order is entered, the receiver is released from any further duties, and the bond that the receiver is posted, which is part of the Act requires a receiver is appointed to post some bond as security to assure it performs its duties. That bond can then be released as well. And that brings about the end of the case. The receiver also needs to file a copy of the order in the real estate records where any lis pendens has been filed to evidence that lis pendens is released.
So going forward, looking at what we can expect now that the MCRA is going to be law as soon as the governor signs it, assuming the governor signs it, what can we expect, Cheryl, as far as going forward? I think one of our first bullet points we put on here was document updates. Obviously, I think it's important to review standard form documents to make sure that they're updated. What ideas do you have on specific document updates, Cheryl, that you're thinking of?
If I were a lender in my loan documents, I would want to update my documents to expressly, upon the lender's at the lender's option, that a receivership can be pursued and a sale through a receivership can be pursued. And typically, lenders don't want to allow debtors to take advantage of receiverships. That would be a default. But at the option of a lender, that a receivership could be pursued, a sale through the receivership pursued, and the owner of the property, the mortgagor, the grantor under the deed of trust consents to that. I would still say it would be appropriate practice in your orders appointing the receiver to authorize them specifically to do what the Act allows the receiver to do, including the sale of assets free and clear of liens. I think that makes sense in your orders.
I think the point is to make sure that even though the statute may authorize it, to make sure that as between the parties, the receiver, the debtor is consenting to a receiver selling property to make sure. I think
it gives comfort to third parties as well that you can point to the contractual agreement. You can also point to the fact that the order clearly adopts the statutory powers and authorities. When you go to your title company or whoever else your buyer to get them comfortable, they'll see those things there, and it just speeds up the process and provides that additional support and comfort for it.
I think one of the hopes here is that having a more robust remedy and providing for a receivership, well, there will be a greater use of receivership where the cost warrants and where the relief that's provided under MCRA is appropriate for the circumstance. I think that is probably one thing that I think we can expect. I do also expect that there will be significant creativity with this statute, and I'm sure that there will be very creative attorneys that will fashion arguments. I mean, that's what happens when you have a new statute like this. There are always opportunities to be creative and to use the MCRA in situations that are unique, or maybe even using it in circumstances that people never anticipated. So I think we will see some of that. David?
So we have about 10 minutes left. We have a number of good questions that we received through the chat room. We'll try to address as many of them as we can. A couple of general observations, however. This statute is not going to be a complete substitute by any means for bankruptcy. This statute won't work, in my view, with a company that has assets in a number of different states and jurisdictions. It'll just be too cumbersome, and bankruptcy will remain the preferred remedy. There's certain sorts of contracts that I would never try to deal with in a state court receivership, like a CBA or a rejection of some sort of employee benefit contract, I think, that might have ERISA implications. On the other hand, I can see at least one opportunity, and that is the Bankruptcy Code prohibits the filing of an involuntary against a farmer, and there is no such prohibition against filing a receivership against a farmer, although you cannot sell farmland without the consent. But if you have a farmer who's out of trust on livestock or otherwise has perhaps made some fraudulent conveyances, this may be a way to deal with that that's unavailable in the Bankruptcy Code. So some of the questions, one question was, can a municipality be the subject of a receivership under the new statute? And the statute itself does not mention a municipality. I would, and I'm doing this from memory, but as I recall, there was a case in the 30s that essentially said that Congress had preempted the field of municipal bankruptcy. That is not, incidentally, the issue that was decided by the court yesterday in the Puerto Rico case, but I think if you go back, you'll find that New Jersey's statute in the 30s authorizing some sort of municipal receivership was struck down. We had a question about...
I want to say one party that you cannot file a receivership against is a party that is regulated by the Public Service Commission. So a utility, I think, is something that you couldn't file a receivership against under the statute. And I'll also say that the statute is not intended to replace receivership provisions and receivership practices with respect to other numerous,
like insurance companies.
Like insurance companies, numerous other entities or types of receiverships that are provided for otherwise in the Missouri code. So.
Yeah, certain sorts of health care facilities also have their own receivership statute. We had a question about what happens with outstanding checks when the case is filed, and I think it's probably safe to say that the statute doesn't deal with that. Is that correct?
I don't believe it does off the top of my head. I can't say that it does, and I've studied the statute a long time, so I don't recall that it does deal with outstanding checks. There's nothing that would prohibit it clearing the bank. Cheryl, do you recall that being dealt with?
I guess it depends on if the stay that would be the only argument, maybe to not.
Well, suffice it to say, I think if the lender wants those checks to not clear, it needs to include in its order, I say the lender, the plaintiff, if it doesn't want those checks to clear, should include in its order a direction to the depository bank to return any checks unsatisfied. Otherwise, I would suspect that they would, in fact, clear.
I see a question about the selling of a residence and how that is really relevant to the Receivership Act, since the questioner is suggesting that it doesn't appear the Act is relevant to anything other than commercial parties. But when you look at the definition of debtor in the Act, it does say that a debtor is any person, and then person would include potentially natural persons. So I see no limitation on a debtor subject to the Act being a natural person.
Certainly, the Act does spend a lot of time contemplating somebody in a commercial situation in which they're operating a business. So that doesn't necessarily prohibit a personal residence from coming into a receivership. And I wanted to say, I mean, one instance in which it would be appropriate for the appointment of a receivership may very well be like a situation in which there's a fraudulent transfer. I mean, that is inappropriate, and a receiver is authorized to recover a fraudulent transfer. And if a person's personal residence was acquired with a fraudulent transfer, I can easily see how a residence could get in there. I'm not saying that's going to be the common circumstance, but
certainly we've seen it where there's a very large personal residence, a very expensive home purchased with monies out of corporate funds, and that would be, like you say, Brian, it'd be perfectly decent target under those circumstances.
It would be. I will say that a personal residence can't be sold without the person's permission,
right,
though, under the statute.
That's exactly right. And the Act really is best suited, I think, for, as David said at the outset of the program, your single asset real estate type of situation. It doesn't cure every jurisdictional question or problem, but it certainly provides a bit of a framework for your receivership.
And then we also have another question about marshaling of assets. And the statute itself does not deal directly with marshaling of assets, whether when there are, and just for some on the call that aren't familiar with marshaling, just very quickly, typically that means there are two creditors with claims against two different sets of assets, and some of those assets might overlap. So there's two creditors, creditor A and B both have an interest or security interest in an asset. in the first asset, and only one of them has an interest, a security interest, in a second asset, whether you can make that person with more collateral go after the its collateral that it solely has an interest in before it can seek that. I think that's going to be governed under what's otherwise available under common law in Missouri. There's certainly nothing in the statute that deals with that specifically, although I think it would be. It seems like it would.
Subject of an objection in the receivership.
It would seem like it would. It would seem like it would be an appropriate subject to take to the receivership court and ask the court to determine, what interest parties have with respect to, either proceeds or in collateral.
And if the receiver should be subject to some order of payment out of one set of collateral versus the other, you may find creditors coming to the receivership court for those kind of determinations.
One interesting question is this whole darn statute unconstitutional because of the contracts clause in the Constitution? Typically, that hasn't been applied, or there's been a recognized exception for in the case of insolvent entities. I think that argument's essentially been made in other contexts with regard to state receiverships. Interesting issue. I don't think it'll be raised anytime soon, and if it is, it'll have to be dealt with. But I suspect a better reasoning would be that this is not an unconstitutional alteration of a pre-existing contract.
And the Missouri statute was modeled after a few other state statutes as well. There are just a handful of states that have tried to flesh out their receivership law by statute. And when we put together the Missouri statute, we tried to follow the lead of other states that have looked at these issues.
And now, this doesn't go directly to that question, but I will say that throughout the drafting of the statute and the preparation of it, issues of preemption were discussed regularly relating to whether or not the bankruptcy code might preempt some of the provisions here. I mean, one thing that we didn't mention before, there is no preference statute here. There are obviously some states that do have state preference laws. We decided not to include preference. I mean, it was discussed, but it was very quickly and unanimously determined that having a preference statute under here would not be a good idea, and actually having a preference inclusion could actually go so far as to cause some preemption issues as well. But we did empower the receiver to pursue Uniform Fraudulent Transfer Act actions, but not preferences.
A technical question was asked as to whether Rule 68.02 will, which is the current rule dealing with the appointment of receivers, will somehow supplant or supersede the new statute.
I'm not sure how, since it really doesn't have any specific procedures in it. It just says a court can appoint a receiver.
It may stay out there.
I mean, it really doesn't provide for anything that's in here. So, I mean, it doesn't provide an alternative procedure from what's in the statute. If it did, then I could say that there could be an issue, especially with respect to procedural issues. The rules have been known to supersede statutes. But here, A, the statute was enacted after the rule. B, the rule does not provide any specific procedures with respect to how things should be accomplished. So it really doesn't supersede the statute.
There is no notice that, the old ex parte efforts that lenders would march into court without any prior notice. The statute specifically speaks to that. The rule doesn't. But it doesn't necessarily conflict. I think a judge is now going to look at the statute and try to see if you've given some notice of the action before you seek an order of appointment.
Well, we're at the 60-minute mark. Thank you, everyone, for attending. I hope this has been helpful. And if you have any other questions about CLE credit or anything, feel free to contact any of the participants and or presenters, and we'll try to get an answer for you. Thank you very much.